Hello, everybody. It's Here we are again, Ed, number 18. We're doing it again, another edition of the Copyright Zone, going after,
Don't tell my wife.
going to go over some things for photographers and artists that are going on in the legal and artistic community. Let me start the show right away. Okay, here we go. This is number 18 for us, so it's getting up there. I can't wait to see what we do with our 20th anniversary eventually. But this one we're going to do, the first thing, we're going to cover something called Here Comes Popeye and Pluto. Who's next? And then we're going to do, whoops, this went out of order. An important SCOTUS ruling that just happened this May, right after we did our last presentation. AI, where's the beef? And oops, I missed one there. Well, we'll get to it all. It's just a preview of what we're going to do. Here's who we are, our email addresses. If anybody has any questions, I'll repeat this at the end. And just to remind everybody, as we always do, Ed's the lawyer. He's the IP lawyer, litigator, actually. And I'm the photographer. And we can always be reached at this two email addresses. So let me
How
jump.
come you have glasses and I don't in the picture, and now you don't have glasses and I do?
My eyes are changing as I get older. For near
Oh,
now, I don't need my glasses. Although I never use my glasses for near, but
uh,
it's age related. So last time we were on, we talked about public domain, and I saw this online. I thought it was really great, going visually what's coming up in public domain and which year. We know this year Mickey and Minnie Mouse from the Steamboat Willie collection went into public domain. Next year, Popeye and all his characters from the Thimbles Theater are going into public domain. Popeye and Bluto and Olive Oil. And of course, Wimpy, I'll gladly pay you Tuesday for a hamburger today. I use that quote all the time in business when somebody wants something. I said, yeah, you want it free today and you'll pay me next time. Right. That'll happen. So these are just some of the ones. Also, Betty Boop is coming up in 2026, Goofy in 2028, and you can see all the other ones coming up, including at the bottom there, Mickey Mouse. The Steamboat Willie is the one that went into public domain, but modern Mickey will go into public domain in 15 years. And that's with the gloves and the correct eyes and the more well-known Mickey that we know will be coming up. So this is something else I wanted to go over, which is FOMO, fear of missing out. And I think this is something that a lot of photographers go through. And the reason they get into bad deals is that they're scared that they're going to miss out on a job. And if it's a bad deal, it's a bad deal. Photographers have a very hard time to say no. We all want to be loved and we want to be accepted. We want our work to be accepted. And I see a lot of photographers just looking at a bad deal and trying to twist into a pretzel in order to take it. And the advice, Ed and I have gone over this many, many times, is simply walk away. You have to learn to say no and simply walk away from some of these bad deals.
we did a lot of webinars on doing what I call autopsies. Dig out some of your older jobs.
Whoops, and I think Ed
And
just
hey, at the end of the day, if you your actual time, some of the jobs that you've done, you've lost money on. You don't want to do that again. You took the job and wound up losing money.
Oh,
Learning the lesson
the other good thing
yeah.
about doing autopsies on past jobs, and I've told people to do this, go back into your files and not only find bad jobs that you're going to learn from, but what about good clients that you forgot about? I've mentioned this to some guys, and they were like so thankful because, I completely forgot about this art director. I sent him a note just to say, hey, and son of a gun, if he didn't have a project for me, because out of sight, out of mind. If you don't stay in touch with people, that's what'll happen. So doing an autopsy is a great idea. Now, this was something I saw online in one of the trade group chat things that I'm in. And it was a photographer who did headshots, and a lawyer agency, an agency full of lawyers, contacted him because they needed new headshots. And he was very good at it. And he sent him a contract to sign, and the lawyers wouldn't sign the contract. They said, we don't do that. And the photographer had the good sense to simply walk away. Um, he knew that he could just get into trouble if he didn't have a signed contract. Ed and I have gone over this tons and tons and tons of time. A little tongue twister there.
By the way,
Whoops.
lawyers do the same thing. If we have a potential client who we perceive to be trouble, forgetting about the quality of the case, we, or I and others, turn them down because you see trouble, bad moon rising.
Yeah, exactly. So I know it's very difficult, especially in tough times, to say no to clients, but you really have to think about, is this a bad deal for me? And doing something with, especially with a law agency, lawyers, anything goes wrong, you're not going to be in a good position. They have unlimited time to go after a case to protect themselves. You need to be protected. You need to make sure your paperwork is squared away. So let's move on. This was the recent SCOTUS case. That's really huge implication for photographers. Warner Chappell Music versus Neely. This was just decided in May, early May, on a 6-3 vote. And as it says down here, and I'll let Ed expand on it, the Copyright Act entitles a copyright owner to obtain monetary relief for any timely infringement claim, no matter when the infringement occurred. As we gone over time and time again, there is a statute of limitations on copyright claims of 3 years. But this had to do with monetary relief, and it's a little bit confusing for a layperson like me.
Okay, let me make it real simple. This case is gigantically huge and is probably the best case for photographers in my memory, at least. Typically, you have 3 years to sue if your image has been registered, and you always want it registered all the time, always, no exception. But typically, you have 3 years within to file a lawsuit. Occasionally, the 3 years can be extended if you could not have reasonably discovered the infringement. For example, you were in prison or you were in a coma. And there are countless other examples. But it used to be that you could only go back on damages for 3 years. So here's the simple explanation. This is 2024. Let's, for argument's sake, say you sue on an infringement that you have discovered in 2024, which has been running for 6 years. But there's no way you could have known that because the initial infringements were in Germany or Japan or whatnot. You can seek damages not limited to just going back 3 years, but going back 6 years or 8 years or 4 years, whatever the length of the actual infringing activity was. It used to be you were limited to 3 years, no more. This is huge. A case that might be worth X can now be worth 2X, 4X, 10X. Maybe this was something that was used as a television commercial 4 years ago, and then they put it as a print ad 3 years ago. Now you can sue for the TV commercial, whereas if you brought the same lawsuit 2 years ago, that TV commercial would be beyond the scope of your lawsuit. So big, big, big.
Yeah, and I know that just so many people are now expats, photographers I know, and I know I've heard of one case where somebody who was living abroad, an American, found out about an infringement here in the U.S. Um, beyond the statute of limitations, but was able to prove that he did not have access to see the infringement here in the United States. And as a result, he was able to file suit. So this is something that does come up. And yeah, the fact that we aren't hamstrung into, not the best word to use at B&H, so that we're not that we're not limited into just 3 years when something's been going on for a long time, yeah, can have a major impact to many, many photographers. And we're getting so many things about AI lately in the news. I will tell you, I have a Google feed to look at things that are AI copyright and copyright, and especially the copyright. Everything seems to be doing with AI in cases that are coming up. And Ed and I will both say what our view of the future of what's going on legally with AI is best described by that great sage, Yogi Berra, who said, it's tough to make predictions, especially about the future. Nobody knows anything. I don't know anybody who can predict what's going to be happening with these legal cases um, uh, pertaining to AI. But we are going to show you a bunch of cases that are going on right now and some of the rulings and just what's going on with them. But this was
Just to give some perspective on this, nobody is going to be able to pick all their brackets in an NCAA tournament. And if it were easy to predict the future, you can go to a horse race with only 8 horses and you should be able to retire. But everybody's predicting this massive upheaval in society, which Jack and I agree there will be. Jack, I want to make one point here before we get into this. I read about 300 magazines, blogs, aggregators, newspapers, etc., a month. Many of them now post notices, including the television station in Miami. NPR does it, where a statement is made that no AI is being used in the creation of the article or the news, whatever. My best guess, and it's only a guess, is that is going to be limited to only, for lack of a better term, highbrow publications like The Economist or Smithsonian or perhaps the Wall Street Journal, where the publication or media is looking to have a certain cachet. AI makes everything easier and so much cheaper that in a consumer publication, typical news program on broadcast television or cable television, I don't see any reason to think that AI is not going to become omnipresent, with very rare exceptions.
Yeah, it's the one thing I think people are missing on some of this is we're seeing just the very beginning. And that's why there's so much confusion in the legal world, I think. But to me, just seeing how digital progressed and many other things progressed in the world, um, we're at the infancy of what's happening with AI, and it's only going to get better. The computers are going to get better. Computers are going to get faster. And even though a lot of places aren't using AI, even the ones that Ed mentioned that are probably going to say we only use humans, I think they will for a few years to come. But I really think in the future, it's going to be more and more AI as it gets better and better, and it's just being used more and more.
Probably the best example of that is McDonald's was using AI in the drive-throughs. I said drive-ins, that dates me. But they were using AI in the drive-throughs, and it was a disaster, and they dropped it. Now, if you're a gambling person, as I am one to be, don't you think that there's going to come a time soon in the next couple of weeks, months, or maybe a year that McDonald's straightens out whatever the problem was?
Yeah, and good, better, and different. We don't really have an opinion on it other than we've just seen this movie before, and we're pretty sure that it's technology just keeps progressing. It doesn't.
Jack, I want to point out one more. I was in a documentary many years ago about photojournalism, and a well-known photojournalist, when I was talking about cell phones replacing real cameras and how journalists and staff photographers would be phased out due to cell phones on the documentary, he says, it will never happen. It will never happen. You'll always need a camera and you'll always need film. This talk about cell phones is ridiculous.
Yeah, and we see so much is dependent on just average citizens getting something on their cell phone, and sometimes that's the only record for
Oh,
certain we've seen.
Jack, let me throw in something here also.
I know where you're going with this.
Uh,
I was going to talk about this
there's
too.
there's a lot of talk about deep fakes and cheap fakes and that kind of stuff. And without getting political, cell phones crowdsource the truth. So if a given politician is in front of a few hundred people or a few thousand people, and a news agency or broadcast network is accused of doctoring the images, the crowdsourcing of 5 or 10 or fewer of the witnesses' cell phone videos fact checks whether or not the image has been doctored.
Yeah, there's only one thing, just to be and usually you're the pessimist and I'm the optimist, so it's kind of strange, or you're the skeptic.
Oh, I'm always a pessimist. I've
Um,
just seen it used.
I think you're absolutely right that right now the fact that there's multiple angles and multiple things, but how long would it take uh, let's say a country, a bad player, to duplicate the same faked event 5 or 6 different angles through AI? In other words, create
With a
an
crowd,
crowdsourcing. Yeah.
if there are human beings on this, I'm going to say the stage or the podium, and you have attendees with their own cell phones, the same images. So if I'm in seat 1 and you're in seat 3 and Barbara's in seat 5 in the third row, and all of our videos are substantially the same, that is going to be the definitive record in the event anybody claims that the network broadcast something that was faked.
Yeah, but what if the event is faked and they are
Well,
qualifying it by saying,
now
"Oh,
we're getting all
have it
that
from multiple
existential
angles."
about it.
Yeah. Well, let's move on because this, again, as Yogi says, it's hard to make predictions of actually what's going to happen. So this was in Rolling Stone recently that the brands, advertisers are beginning to turn against AI. A lot of hype from big tech and the rush to integrate trendy new tools in every aspect of our lives. The backlash seems inevitable. And while there is a backlash to it, as we say, I think that technology is just going to keep progressing forward, especially in the visual arts, uh, and in many other areas. But the one that I'm concerned with is what's it doing in the visual arts, and um, it'll be interesting. And while they say that they're turning against it, I'm seeing young photographers who've grown up with the computer and are very comfortable in this environment, which a lot of my contemporaries aren't with what's going on. They're learning to use AI not just to create images, but to use it to what are other ideas I can do along these lines? How can I write my proposal? How can I? They're using it as a tool, not as a crutch, not as something to generate images. But then again, we showed in one of our lectures, Ed, where somebody shot models in the studio and then placed them in these incredible sets that would have cost a fortune to either build or to fly to with the crew. And so the photographer is making the shot very simple. He's getting the client exactly what they want in the wardrobe. They're showing it a certain way, and they're placing that model in an incredible place.
Simple real life example is one of my cases where I represented the model, and she did an ad. Going to change the dates and so on, and the corporate names, but she did an ad for, let's say, a 1995 General Electric dishwasher, and just by using Photoshop, they used her in an ad for a 1998 and a 1999 General Electric dishwasher. Now, that was done by simple Photoshop. Think of what AI can do as opposed to just Photoshopping. She never stood next to either of the latter dishwashers, but they ran the ads anyway, all over the country.
Yeah,
They saved
well,
money. They saved money on the model, and they saved money on doing a brand new shoot. They lost money when we sued them, but most people don't sue.
but it is if this conversation is getting confusing to some of our viewers, I will tell you it is a confusing subject, and we're just trying to go over different aspects of it. We're just poking at it basically, but
It's the 10,000-pound gorilla.
yeah. So this was interesting in the news too. Scarlett Johansson, well-known actress, um, and I'm using this picture from Vanity Fair because I'm not going to pull just a picture of her off the internet. If you notice, Ed and I usually pull full things like a magazine cover, which we can do. Otherwise, it could be copyright infringement. But showing a magazine in its entirety like this, it's not a problem. So,
Or a package. Same goes for a package.
right. Um, Scarlett Johansson was the voice in this movie called Her, which was a movie about AI and about how uh, uh, Jaquan Phillip Phoenix.
Joaquin
Joaquin,
Phoenix.
I'm having a horrible time with pronunciation today. Joaquin Phillips, Phoenix.
Phoenix.
Anyway, the star of this film fell in love with her voice. You never saw her. She was the AI in it, and they used her voice. And what happened since then, she was contacted by OpenAI to use her voice in OpenAI's personal assistant, which was named Sky. They contacted her. She turned it down. Um, they went ahead with an actress or somebody. I don't know actually how they did it. Probably pulled it from Scarlett Johansson, but they went ahead with her sound-alike voice. And guess what? She's suing them. And I think she has a great case because rather than
Life 10
say, go ahead.
Life 101. Big shots can be incredibly stupid.
Yeah.
These are people who should have known better. This is so dumb. Scarlett calls me all the time. Unfortunately, she didn't call me for business this time.
Yeah, well, I won't, I'm not going to go into that. Anyway, one of the reasons she has a really, really good case is the fact that she was contacted ahead of time and refused it. Her case is not about, oh, I heard this and I think it sounds like me. This was, they approached me to do this. I said no, and they went ahead. Does it sound like me? Yes. And the CEO of OpenAI said he was a huge fan of the movie and of her. So,
Smart. Very smart.
yeah, yeah, they're going to have
Shoot me now.
yeah, they're going to have a very hard case to defend on this. So here's another one. Now, while she said no to it, this was real interesting. Al Michaels, who will not be covering the Olympics himself, will have his voice covering the Olympics. He was contacted by NBC, and he was very skeptical, he said, until he heard it. And he said when he heard it, it changed his mind, that it sounded, as he said, only 2% off of perfect for him.
I'll tell you what changed his mind. A check, a large check changed his mind. But he did consent, and that's the difference.
Yeah, gee, let's see. I'm not going to get hired, not make any money. I can sit
Right,
at home and collect money because they're going to use my
right.
voice.
Tough
Uh,
choice.
yeah, I
Those of
mean,
you who think that AI is not cost efficient, this is perhaps the perfect example, because Al Michaels used to make almost $1 million per football game that he broadcast. So he did not appear cheap.
in his heyday, I'd say he was well worth it. It was always fun to listen
Yeah.
to for me. Um, but yeah, this is one of the areas where, again, going back to everybody who was suing AI, well, we're going to get into that in just a minute. We're going to talk about the New York Times and some other cases. But it's going to eventually, I think, come into a point where money is going to change hands, where AI is going to be paying for a lot of what they're going to be using. So I threw this in for you, Ed, Tennessee law and Elvis. I have no clue whatsoever, so I'll leave it to
Okay,
you.
we'll make it quick and blunt. Tennessee is, or I should rephrase that, Nashville is in Tennessee. Nashville generates lots and lots of money, as probably now.
Whoops, you just froze up for me. Um, I don't know if you're
The
on or not, or if
music
it's
industry in particular.
Eddie, back up a
Sorry,
little bit because
can
you froze on mine. I don't know if I didn't hear anything of what you just did.
you hear me now?
I can hear you perfectly.
Okay. It's the home to Nashville music industry, big, big, big bucks. Tennessee wrote in a law, a very good state law, great for all creatives, anybody within the sound of my voice, except art directors and ad agencies. Gives very specific rights, similar to New York, and better in some respects, to voices, images, and likenesses. And it specifically addresses AI imitating or copying, whatever term is appropriate. I don't know what term is appropriate. Um, for example, Elvis Presley's voice. And of course, Elvis was from Tennessee. So, and Graceland is in Tennessee. So there was a lot of money behind this. It's an excellent, excellent law. And what goes, or what does not go in Tennessee might go in Arizona or Montana. But if it's music related, the odds are it's going to get used in Tennessee. If it's movie related, the odds are it's going to get seen in Tennessee and so forth. Excellent law.
Very good. Now here on the flip side, Paul McCartney uses AI to pull John Lennon's voice off an old track that was unusable and made it usable to create a final Beatles song. So um, again, you're seeing people use it not illegally, but using it to solve a problem or issue, or to create something that they can't create without it. That's why we keep saying that the technology and the uses are just going to keep marching forward.
Those of us of a certain age remember Nat King Cole, who had been dead, and his daughter, Natalie Cole, who, of course, then was alive, is no longer alive, doing his song Unforgettable as a duet after Nat Cole had died. No AI, but they did it using the techniques available 15 or 20 years ago, and it was a big selling hit. Now with AI, it would be even better. And they're both dead.
And as we talked in the past, that dead celebrities actually sometimes make more money after they pass than when they were alive. their estates are pulling in huge amounts of money. But that's another lecture.
That's
Um,
because they usually die before their wives. So the wives collect, get every last ounce.
This was something that just came up. If somebody hasn't seen it, I would say definitely check this out. Toys R Us, just to show you nothing ever dies. Toys R Us has been resurrected in Macy's. They have the name, and their toy departments are, quote, Toys R Us, using the same branding and Jeffrey the giraffe and everything else. And this is something I it strikes me right away because Toys R Us was one of my major clients. I was one of their main children photographers. I never did the toys themselves, the still lifes, but I photographed a lot of kids over the years for Toys R Us.
And there was a time when Jack, Toys R Us had 5 to 8 photographers in the New York area that they used with great regularity until they got rid of them.
Yep. Um, so anyway, this is a video, a commercial that they produced using only AI. Now, there are some glitches in it. Now, I don't know if you could call them glitches, but they have things like bicycles melting into themselves. The child in this who tells the story, his features change slightly because it's very hard to keep the same character throughout AI right now. But the technology and the way it looks and the way a lot of people who aren't um, as visually sophisticated or literate as a lot of photographers or people that look at this stuff all the time, this came across very well. It was surprisingly good. Um, and they will make it better and better. Again, we're seeing the very infancy of this, the very baby steps of what this stuff can do. And it's fairly impressive, I think. Um, so yeah, I mean, we don't want to be sounding like we're banging the drum for AI and everything. Um, we're just trying to be very realistic on what we see AI as far as what it's doing in the industry. Um, and this is we're going to get into some more AI legal things, but I think this one's very important. People are saying, "Hey, you stole my idea for your book, your movie, your TV show, your podcast," um, and they think they have a case. And sometimes they do. Many cases they don't. There's something in copyright law known as protectable elements, and it's sometimes referred to with a French term, scenes of faire, scenes that must be. And this is when you're doing a certain genre, there's certain things that always occur. And it happens over and over. You can't avoid them. One of the things people talk about, if you're doing something about the South Bronx in the 70s, when there was Fort Apache and everything else, you're going to have junkies, you're going to have prostitutes, you're going to have burnt out buildings, and scenes like that. If you're doing a mafia movie, you're going to have Italians. You're going to have um, uh, uh, certain things that are common to that genre. And just
Here's, especially if you're doing anything which involves history or commonly known facts. So there are dozens of biographies of Ronald Reagan. There are dozens of books on the New York Yankees. There are dozens of books on fix it yourself and do it yourself projects at home. By the very nature of historical facts, and this is the way to change a flat tire. If Jack wrote a book on auto maintenance 5 years ago, and I write a book on auto maintenance today, Jack is going to think I ripped him off. But there are thousands of books that have facts that are shared. That the Yankees won the World Series in 1927 and that Babe Ruth hit 60 home runs is going to appear in any book about Babe Ruth or the history of the Yankees, no matter who writes it. If it's a medical book, and we've had this very specific case, a medical book on how to perform plastic surgery on someone's nose. Well, if there are no new techniques and someone writes a 50-page book in 2000 and somebody writes a 65-page book in 2005 with some updates in terms of new surgeries, the person who wrote the book in 2005 may very well have read the prior book, but that is not grounds for copy in and of itself, not grounds for copyright infringement. If the second author literally copied the first 50 pages or 20 pages, then you would have a case.
So on the way to protect yourself on all these things is to always have paperwork. Talk to a lawyer. If you do have something and you're going to pitch a book or a movie or a TV show or anything like that, the person you're presenting it to, you can have them sign a non-disclosure or some kind of an agreement to show that you brought that to them. People have sued on these things, have won. Many people have brought up some of these things. I've seen some where you tell people, yeah, I see what you're saying. The similarities are there, but it's not the same. The stuff that
Not
they're
enough.
copying is not exactly not enough.
Not enough.
Then it brings up you can't copyright style. Again, this is going to go a little bit into AI. We're going to go much deeper into AI. You can't copyright a style, but Ed says you can protect it.
Okay, the word protect is in quotes, and it's very nuanced. But here's the basic idea, and I will use a real life case as I am wont to do. An illustrator, I'll say a she, had a particular style, and she was doing very, very well. And then someone 1,500 miles away started copying her style, no doubt about it, and charging about half of what the first person, the original person, was charging. And the creator, the first creator, let it go for years, to the point that her once thriving illustration business disappeared completely. What she should have done was, when she saw this very similar style, not infringing at the beginning, she should have had an attorney write a letter, and I've done this any number of times, and again, nuanced based on the facts. The lawyer writes a letter that says, we noticed your image that you created for, Time magazine. We noticed the illustration appearing in the July issue, and it is strikingly similar to our client's illustration. And we're concerned, and we're analyzing this further to see if we're going to take any legal action, but please be on notice. And then in legalese, it says, you're best off staying away from doing anything similar to what my client is doing. This serves as a prophylactic. It's a preemptive strike, because when people get a lawyer's letter, the last thing they want to do is risk getting sued. So maybe they don't go to that same well again. Maybe they do. And they're willing to risk it and saying, you can't copyright style, and I'm going to keep doing it. But most people who are sole proprietors, small businesses, creative people, don't run the risk. But you got to jump on it right away.
Yeah, but in many cases, I've seen photographers say, oh, they copied what I did, it's the same look. And we have to tell them, yeah, but unless the elements are copied exactly, you can't copyright that style. If that was the case, and it's one of the issues that comes up in AI for me when I talk to people about it, is if you're saying AI looks similar but not exactly, if you don't let AI do that, if they could, not allowed to copy a quote style, but without all the elements, then what prevents a photographer or an illustrator suing for a similar look? like I photographed in the same type of look as Norman Rockwell. I never copied any of his images, but I studied his images. I looked at the way he handled body position, the storytelling, how everything was very concise in the middle. Um, and I learned from that and I used it. I didn't copy any of his paintings in any stretch, but I definitely was influenced by it. If you could copy
Simple.
the style, I would be able to be sued for something like that. And people who shoot things that look like Ansel Adams, then, his estate could sue over that or anybody else.
Simple example. I could try to write in the style of Ernest Hemingway. No problem with that in trying to do it. Whether I would accomplish it, there's a million reasons why I wouldn't accomplish it, but I can try. And if it sounds to the reader that it's similar to Hemingway, there's no case, or any other author. I just happened to pick a dead one, but any other one wouldn't matter.
Well, it comes into some interesting cases that we're going to go over and something I call where's the beef? And this is because of some of the cases that are coming up. If anybody remembers that great Wendy's commercial from way back when on where's the beef? There's no hamburger here. The first one is 8 major newspaper joined legal backlash against OpenAI and Microsoft. And everybody seems to be suing everybody on this. I'm seeing more and more cases coming up.
It's frozen.
Now, in this particular case, OpenAI and Microsoft moved to dismiss the newspaper publisher's copyright lawsuit. And it's important to understand why they moved it and why we think they're going to be successful with it, and why we think the New York Times lawsuit against AI is going to be more successful than these.
Well, let me elaborate. Yeah, let me elaborate first on the Times before you get to this. According to what I have read, they stole, and that's the word I like to use, stole more than 50% of the materials that were stolen were taken from the New York Times. If they had taken 5% from Reuters and 5% from the New York Times and 5% from the Wall Street Journal and so on and so forth, then the New York Times would not have as good a case as it has now. The Times can say, and I've done this in any number of stock photography cases, which I'll use the Bo Jackson example. You can get a picture of the athlete Bo Jackson for $50 from a stock house. You couldn't get my client's picture of Bo Jackson for any amount of money, and yet it was stolen. Here, the Times is going to say, our stuff was so much better than everybody else that more than 50% of the stuff you took from us. You could have taken it from The Economist, the Wall Street Journal, Barron's, etc. So why'd you take all the stuff from us disproportionately? That's because you knew our stuff was better, so you stole more of it. So in my legal opinion, for what it's worth, from what I've read, the Times has New York Times has a much better case than any of the other publishers or outlets.
Also, my non-lawyer opinion on it is the fact that the New York Times is really not going after copyright infringement itself. They're going after the use of their archives, which is something that they license. And in my opinion, they're going after licensing more than copyright. And let me explain that a little bit more with some of these examples, and why OpenAI and Microsoft are looking to dismiss the newspaper publisher's copyright. And that's because they fail to assert tangible complaints of copyright. What we mean by that is that they don't have actual evidence. They don't have exhibits to show, here's my work, here's the copy. And what Microsoft has said is the AI developers add that the mere possibility that a user could prompt users to use GPT-based products to produce work that infringes on the publisher's article is not enough to state a claim for copyright. What that means, what they're arguing is the potential of infringement does not say that there is infringement. You have to have an infringement exhibit. You have to show
And
here's the infringement, not that it could possibly infringe. It's like I could possibly steal this car.
ladies and gents, Jack is now going to get into some cases, and I frankly don't understand every single copyright complaint that's ever come out of my office and every single copyright complaint that I've ever seen. You have to compare the original with the alleged infringing, if it's an image. So it's a side by side. Here's the original, here's the copy. We tend to print them on the same page, and it's in the complaint. If it's not in the complaint, if you don't show that Jack's photo registered in 1995 and appearing in Ladies' Home Journal was used by Time Magazine in 2005, and you have the pictures side by side, if you don't have that, you don't have a case. I don't understand how presumably high-priced lawyers filed papers without doing the very basics. It's like, I can't even think of a camera equivalent, Jack. I guess it would be like cleaning your lens before you do a shoot. I don't understand how the possibility of infringement means nothing in this context.
Yeah.
None. If let me just go one more second. If Jack infringes on my photo and I say, because Jack infringed, he's putting it out in the marketplace and there's going to be other infringements, yes, then I have a leg to stand on because I have Jack already infringing. But just the potential of an infringement, no one could create anything. Anything can be infringed.
Yeah. So let me move on. But yeah, that's why it's called copyright. It's about copying, the right to copy. In order to sue for copyright infringement, you have to show exhibits in court of the infringing work. We had just covered that to death. This was one case that came up. Sarah Silverman and several other authors in the same case sued OpenAI for using their books for AI training. Okay. The portion of her lawsuit, it says partially dismissed, but basically what the judge said is put up or shut up. Where's your exhibits? And this judge expressed skepticism on several of their claims. She said, nowhere in the plaintiff's complaint do they allege that the defendants reproduced and distributed copies of their books. Nowhere did they say, oh, they're selling a copy of my book or something similar to it here and here. They couldn't produce a book that showed it. The claim of risk of future damage to their intellectual property was too speculative to consider. And the judge also emphasized that the plaintiffs have not alleged that ChatGPT output contains direct copies of the copyrighted books and must show a substantial similarity between the outputs and the copyrighted materials. In other words, where are the exhibits? Now, she's allowing them to refile the case, but what she's saying is refile with exhibits. Otherwise,
now what she's saying is, what she's really saying to the lawyers is, you guys are incompetent. I can't believe you put this in front of me. That's what she's really saying.
Well, at the same time,
like law student time.
Yeah. At the same time, Time Magazine and OpenAI signed a multi-year content deal where OpenAI is going to use Time's archives. Time is actually going to then incorporate OpenAI into their system and what they do. They're looking to step up into the future, basically. So I think that this is the model. This is a framework that we're going to see going forward. Now, I said when we first heard about it months ago, Ed and I both said the New York Times was the best case we've seen come up for a variety of reasons. I said, I think it's going to end in exactly this, that there'll be a licensing agreement. Eventually, money will change hands. Ed's a position on that is that he thinks it's going to go to the Supreme Court, which would actually be very interesting. My feeling is
Just,
they're not
yeah,
going to spend the money.
just an educated guess, because I think the Times position is so good that if they win, they are basically can put some of these companies right out of business. That's how much money is at stake with the Times.
Yeah.
Not that I'm a fan of the Times. I've sued them many a time, many a time. The other thing, Jack, about the Times, to be so that the audience knows, it's very hard for either of us to know what materials from the New York Times were stolen. The articles may be copyrighted by the Times. They may have been copyrighted by the journalist. Same thing with the photographs and illustrations. I don't know what the New York Times owned, what they had in their archives, where they had the right just to license it, or where they had no rights to license it. I have no way of knowing that.
Well, this was also something interesting for me that came up in one of my feeds. Um, in China, they granted copyright protection to AI generated artwork. They're saying the person who created the work using AI, that there was enough human input to protect it. Now, this was in a lower court in China. It has nothing to do with any of our courts here, but the reasoning and the way it's looked at will be looked at by courts all around the world. And one of the things to understand that the US isn't an island in all this controversy, that if laws are passed in other countries that make it easier for AI companies, they're going to go to those countries.
I have any number of photographers working out of Costa Rica, Portugal, the EU, Argentina, all over the world, because it frankly makes more financial sense for them to live cheaper, work cheaper, and they're still on the top of the game, and their clients couldn't care less.
Yeah,
Could not possibly care less.
I know one New York photographer, a friend of mine, who has a studio in Argentina, and he shoots there
Yeah.
regularly because his shoots take usually a lot of models. They're big productions, and they save so much money by shooting in Argentina, and he's done it so many times. And they pick Argentina because he can get all the ethnicities that he wants in the shot. There's a great mixture down there. So he
And
says,
save a fortune on models and modeling agencies. A
yeah,
fortune.
all his resources are there. So, and I'm finding more and more photographers I know are becoming international. Another friend is living and working out of Tokyo right now. So it's very interesting to see what's going on right now. So these things, while you're saying, oh, well, this isn't the US, this is China, and it's not going to affect me. The world, as far as some of these things, are getting smaller and smaller. Um, Oh, this was something that came up on one of my feeds. A photographer complained on social media about a big box store, I don't know which one, making copies of his photos without permission. And what happened is everybody kept telling this photographer, oh, your business model is incorrect. You should be doing this, and the correct way to do it is doing this. Instead of supporting each other, it just seemed to me that people were criticizing. I pointed out that when I was on the board of PPA, we sued Kmart for doing that, for making copies in their photo departments of copyrighted works. They stopped doing it. They retrained their workers. Some of the other big box stores like Walmart came to PPA and said, we'd like to have you help train our people. If you're having a problem like this with one of these big stores, big chains, you can't work from the bottom up. You have to go from the top down. And that's why we have trade associations. Organization like PPA will not contact that store. They'll contact the big box company themselves, whoever it is, and deal with the people there and tell them that if they don't retrain people, if they don't send out things to protect photographers' copyright, they could be facing a lawsuit.
I have a difference of opinion with Jack there because I have little to
That never
zero
happened.
faith. I have little to zero faith in any trade associations for photographers. I've been doing this for 45 some odd years, and I can't recall any trade association doing anything that had a better effect than being sued in court by a single photographer who has all the sympathy of a judge and a jury, as opposed to a trade association who's representing hundreds to thousands of people with allegiance towards no particular person. Just my
Well,
experience.
I just wanted to see where I'm at. Well, my experience has been a little bit different because I did have a positive experience when I was on PPA, and I saw what the power of a lot of people can do, and we were successful in for a period of time. But obviously, that was about 10 years ago, so it's time to do it again. This is something else that came up on the internet, and again, people like to be ticked off on issues on the internet, and everybody has a keyboard, so they're an expert. Adobe put out new terms of service. And I will say it was extremely poorly written and completely misunderstood. It created all this outrage because people like to hate Adobe. And then Adobe revised the language. They didn't really change the terms, but they tried to clarify what it is. And then I recently saw this, that another company started taunting them, as this says, on their terms of use. The funny thing is, this company's terms of use is pretty much the exact same as Adobe's. It's just the language is misunderstood by so many people. And the language in their terms of use are there because they need to get a licensing from you in order to put your work on the internet, to use the internet, to have things even on social media. If you read any of the social media sites, they have the same thing. They are getting a license from you in perpetuity to your work. Otherwise, it would be illegal on their part to have it on their servers. And the way the internet works is you have to sublicense it to other servers, because that's a simplistic answer to how the internet works. It like leapfrog from this server to that server to another server. That's why you can see things instantly from all around the world when you do a search or something else. It's the mechanics of the internet. And all they're doing is getting the rights that they need to use the internet. And people misread it as they're going to steal my work and they're going to license it to somebody and they're going to use it for my picture for this or that. And they're going to sell it to a big box, Walmart, to use my picture. No, if they did that, then the groundswell from that would be unbelievable if they ever did that to anybody's picture. Understand, but I will say, Adobe's lawyers, and I've run into this in many occasions on dealing with big corporations and their in-house attorneys. They write these things horribly. They overreach on some of it in the terms of what they write. But in this case with Adobe, I will tell you, I read it, I understood what I was reading, and I understood what they were trying to say and do. They're not looking to use people's work for training. They state explicitly that they do use things that they have permission for training. But the other part about getting a license in perpetuity forever is because they need to do that on the internet. It's just the way the internet works. Anything you want to add in on any of that, Ed, before we
Nope, you nailed it.
I think we're going to call that a day today. I think we used up time. I don't have anything else really important to say. I do want to go back that if anybody has any comments or questions, we're more than happy to hear from you. And you can either contact us through B&H, or I will just share this screen again. Here's our email, and you can reach us on our email. We're more than happy to answer or confuse you, whichever the case may be, what your question is. And we want to thank B&H once again for use of their hall in order to get out all these little tidbits. And we hope that you pick up something from all of this that you can use, or at least it enlightens you on some of the very complex issues that are going on out there. With that, Ed, I'm going to bid you adieu.
Thanks, ladies and gents. Does this mean I don't have to look at you anymore?
That's it.